Good afternoon, everyone. My name is Elisa Mick, and welcome to Parallel Session 1. Please note that those of you who want to attend the other sessions, the Parallel Session 2 and 3, you have to go to a different link. So this is the link only for Parallel Session 1. But I suspect that this is going to be the most interesting session because it is on tort law and AI. So it's going to be a real treat. We have 4 speakers. 3 speakers will be presenting live, and unfortunately, the duo, the 2 speakers in the 3rd position, had to cancel. There was a bit of an emergency, and we will just play their PowerPoint via commentary. Just one last housekeeping thing. I hope it's okay with everyone. We're going to keep the Q&A until the very, very end. And of course, feel free to contact me via the chat function, and I will moderate as best as I can. So our first speaker is Daria Kim from the Max Planck Institute for Competition and Innovation in Munich, Germany. And Daria's talk is on torts law and artificial intelligence, a legislative reform in view of AI autonomy. Daria, the floor is yours, and I'm going to mute myself.
Thank you very much. Yes, the slides are there, right? Yes, hello everyone. I just told Elisa that I used to work actually at CUHK for 2 years. I'm very happy to be back, even if it's in the online format. So I'll start with a short jurisdictional disclaimer. Currently, I'm based in Germany, which means that I'm more familiar with the European legislators' agenda with regard to AI and liability frameworks. As we know, tort law terminology can be very jurisdiction specific. What I refer to when I talk about tortious liability, I mainly have in mind extra-contractual liability, the term more used in the context of European continental law. At the same time, I believe that notwithstanding the jurisdictional and terminological differences, the core public concerns that are raised by AI are very relevant across the jurisdictions. Let me start with the general observations. It is very common, very usual that new technologies raise new challenges, new public concerns, and new legal questions. And usually the overarching question is to what extent the existing legal order is relevant or adequate to meet these challenges. In the EU context, it's known as the fit for purpose assessment. Recent developments in the field of AI, especially machine learning, triggered intense debate and expectation of a paradigm shift, not only in tort, and not only in the context of tort law, but across legal domains. So with regard to liability framework, the discussions are still going on, whether we have gaps in the liability framework. A number of reformist proposals are being discussed by the policymakers and by the legal scholars. The overarching questions are to what does AI mean for tort law, whether how the liability framework can and should respond to the new challenges, and to what extent the existing principles and concepts can be sufficient in identifying and allocating liability for AI-intermediated harm. Where does the EU legislator stands in this regard? First of all, I would like to mention that EU has a very comprehensive agenda in addressing different challenges by AI. Overall, it favors a human-centric approach, which means that the overall principle, the core principle, is for the protection of fundamental rights and values. And basically, any policy initiative with regard to AI evolves around the notion of trustworthy, human-centric, and safe AI. It's not my purpose to make a detailed overview of this agenda. I would like only to draw your attention to two major pieces of legislation that are still underway. The first one is AI Act, and the second one is the initiative on the adapting liability rule in the digital age and artificial intelligence. My goal for today is, however, to stay at a relatively conceptual level and therefore more jurisdiction neutral level. And I will focus more on the question, how do we understand the problem in the first place? Because the answer to the above stated questions crucially depend on how do we understand these challenges, the real life challenges and challenges from a technical perspective. This corresponds to the so-called ends-means approach or problem solution approach in the policy making, where the policy measures are, the normative validity of the policy measures is assessed relative to the policy objectives. This leads me to the two component structure of my presentation. In the first one, I will revisit certain widespread characteristics of the AI systems, and in the second part, I will outline some legal implications, legal questions that I'm examining in the paper that I'm writing for in the context of this conference. Let's start with the technical clarification. I will present two contrasting views on the problem. It has become very commonplace to characterize AI systems as autonomous, opaque, unpredictable, black boxes, and so on. These characteristics are viewed as causing major uncertainties across the legal domains, not only in tort law. And it is important to emphasize that such characteristics are mainly associated with the so-called machine learning systems, because AI is a very broad term and encompasses different other computational techniques. So I would like to present two contrasting views, and let me start with the two passages from the relatively recent report of the European Commission. The first one explaining the opacity of AI system, and the second one explaining the autonomy of AI system. You don't need to read this paragraph, but you can catch certain phrases such as the difficulty of identifying the causal link between the human conduct and the output, or the risk, the damage that the algorithm no longer implement the human written code, that there is certain that AI systems are basically black boxes where it is very difficult to trace their decisions and their choices to the human instructions or the human decisions. The same goes about AI autonomy. AI systems are often represented as self-learning systems, where the overall implication is that AI systems might have at some point the agency of their own, and the human input is basically minimal or absent. In this regard, one might recall the resolution of the 2017 resolution of the European Parliament, where the European Parliament called on the Commission, in view of the emerging novel AI technologies. It suggested the idea of introducing e-personhood for very sophisticated autonomous robots, where basically these electronic persons would be allocated the damage or liability damage for any harm that they cause. This triggered a very strong response from the computer science community and from the community of AI researchers. You can still find this open letter of researchers in AI and robotics addressed to the European Commission. And I would like to highlight one of the paragraphs. It's a relatively short document, and I would like to highlight this passage where AI researchers state that characteristics such as autonomy, unpredictability, self-learning capacity are exaggerated, are evaluation of the actual capacity of even most advanced AI systems, and the justification that it's not possible to prove the damage and liability simply does not hold true. This led me to question what exactly do we mean by the characteristics such as opacity, autonomy, limited predictability, and so on. So this curiosity led me to a collaboration with a group of machine learning researchers, technical experts, including machine learning researchers last year, where we examined this capacities and such characteristics more in a technical terms. You might ignore the part about patent law because it's the clarifications that we provide in this paper can be relevant for the analysis of any legal issues that hinge upon the understanding of the human-computer interaction in the context of machine learning. So this paper is in the open access. We cite a lot of technical literature, and I don't have time to go through all the assumptions right now, but I would like to summarize the main findings. Autonomy should not be used interchangeably with automation. The key difference is that the automation means that the task can be carried out with little direct human intervention during the implementation, but for that the computational process needs to be conceptualized and configured by humans in the first place. There is no autonomy in a sense of freedom of decision making or freedom of choices. AI systems cannot violate the constraints and the instructions provided by a human. If you train an artificial neural network with a certain equations or cost functions, a model cannot disobey, ignore, or violate such equations unless there are some bugs in the software. The self-learning capacity can only be used as a metaphor. The opacity stands for complexity of the systems, and in light of this clarified technical understanding, I would formulate the legal problem a little bit different. So the problem subsists not in that human control completely dissipates or disappears, but it becomes highly dispersed and distributed among numerous actors. I will make my slides available, and you can check the quotes that I provided here. That basically the black box metaphor is often misunderstood. The non-deterministic nature of these systems is often misunderstood. And I very much like the wording, how David Watson put it, stating that the rhetoric of anthropomorphism in AI might be helpful for explaining the technical complexities to audience with minimal background in computer science, but it is basically often misleading and even potentially dangerous. So let me now switch to the legal implications. Here I would like to, since we are very short in terms of the time, I would just like to outline the major directions of my analysis. So first of all, it led me to conclude that basically I don't see the need for a radical transformation of the tort law liability regime in general. Yes, there might be incremental adjustment. We might need to reconsider how certain concepts apply to novel real-life constellations and scenarios, but a fine-tuning incremental adjustment seems to be more appropriate. But the question is, what exactly needs to be fine-tuned? So if we start with the objectives of liability rules, my conclusion is they still hold. We still the compensating of the injured party is still relevant because we can hardly think of the new types of damage or harm that can be that can be caused by the deployment of AI systems. But also a more rigorous technical understanding leads us to conclude that we should not abandon the second goal of incentivizing the risk mitigation. And if we look at, if we take a closer look at the factors of risks, we can find that there is still room for human control, and such risk can materialize only if the AI systems are not properly tested, monitored or controlled by humans. In this regard, it's also very important to consider how liability for tortious liability intersects with the non-compliance liability. This is especially relevant in the EU context in view of two parallel legislative documents that I mentioned earlier. The human causation is also not does not become irrelevant. As I mentioned, in my understanding, the human causation still takes place, but it's highly dispersed and becomes highly distributed and multifactorial. In this regard, in the paper, I consider the notion of uncertain causation. We know that this concept is there is a long-standing discussion with regard to this concept. And jurisdictions develop different approaches, how to avoid the all or nothing outcome, especially such as different presumptions, the shifting or lowering the burden of proof, extending strict liability regimes, and so on. I'm also considering the work on causal proportional liability and the applicability of enterprise liability. Bottom line, the appropriateness of the existing concepts and mechanisms in my view, should be considered first before reinventing tort law from scratch. And the final comment, I'm going to the final point for this presentation is the question of whether the concept of fault is still relevant. There is a tendency in the legal discussions towards expanding the strict liability regimes due to the above-mentioned characteristics of the AI systems. And what I'm trying to do in the paper, taking a more rigorous approach to the potential causal relationship between human input and the harm that can be caused by AI systems. It seems to be that there is still room for the concept of fault is still relevant. So overall in the paper, I think the relatively novel contribution would be to consider the notion of the standard of conduct, how it applies throughout the development cycle of AI, especially with regard to the training of AI systems. So I outlined a few conclusions, tentative conclusions at this point. The main point, I think, is that the more realistic and non-anthropomorphized depiction of AI might yield a more rigorous legal analysis, and overall the liability regime should remain differentiated, but a more robust understanding of AI system might lead to a more to placing a little bit different accents within the liability framework compared to how they are placed in the current discussions. And with that, thank you very much. I'm happy to be, I think, on time.
Thank you so much, Daria. I must confess, I actually forgot to time keep because I was listening. So one of our admin colleagues, thank God she was timekeeping. Otherwise, we'd be talking until 6 o'clock. So thank you so much. Okay, guys, let's proceed to Sara Migliorini. And she's from the University of Macau and from the University of Singapore Management University. So one leg in Singapore, the other leg in Macau, and the presentation is on tort law and AI. This time I will time keep, I promise. So this is 15 minutes. We're starting at 16:43. Let's make it 16:44, so it's 16:59. Thank you.
Okay, yes, thank you, Elisa. I'm very glad to share the floor with you and the speakers, and I'm glad that I agree with Daria on so many things. So you'll see that our presentation really, without previous communication, really kind of converge. So I'm going to share my slides as well. Yes. Okay. Yes, so also my topic, very general one, try to understand what conceptual adaptations we need to make to accommodate the deployment of AI in our society. And I'm just going to try to make 2 points with this presentation, and probably I will go deeper in the paper on some issues. So the first remarks will be about regulation of technological risks. So of course, is what AI poses, a technological risk, and then the conceptual adaptations for tort law. So of course, we already mentioned that the traditional aim of tort law is compensation, and by compensating an unfair harm, promoting fairness and ensuring fairness within our societies. But of course, we know that with new technologies, we have been exposed as humans to new risks of harm by machines. And this is something that started with the first industrial revolution, even though we are probably undergoing the fourth. And every time we have been confronted with these new risks of harm, some major evolution has happened in tort law, for example, product liability, but also then compulsory insurance schemes and other issues. So in our complex technological societies, we expect tort law not just to promote fairness by compensating someone who could be who has been injured by an AI system, but also we expect this area of the law to regulate AI itself. And by regulation, we of course mean deterrence of certain behavior, something that Daria mentioned as well, and also the encouraging of other kinds of behavior and also investment and innovation in AI. So it's a really fine line that and a really difficult task that we ask from this area of the law, but it's not new. And it's not particularly related to AI. It's something that we have seen and we experience every day actually for other technologies. So I think we should take a step back, and this is part of a broader research that I'm doing right now about the transnational regulation of AI. And we should reflect upon how courts, when they adjudicate and they apply tort law, what's their relationship with regulation in the sense of state mandated regulation that will certainly come with respect to AI, not only in the European Union, but globally. We're seeing a movement in the past 2 years that is really clear towards some kind of regulation of this technology. So when confronted with technological risks, states will have to choose whether they want to leave courts free with basically no guidance, applying the principles of tort law, enforcing contracts, of course, but also claims in tort law. And particularly in common law jurisdiction, this is usually seen as a good thing, a possible thing. And if we refer back to economic theories of law, the classic ones would actually claim that it's a better choice for states to leave courts alone with their principles of tort law and simply refrain from regulating. And so regulation as adopted by states is seen as something really harmful, positively harmful most of the time by these theories, because regulators are subject to capture by interests, or because the parties would be the best placed to present evidence to courts. And of course, this places courts in a better position to regulate the technology by adjudicating case by case. But there are other theories that have emerged, according to which, of course, courts also are flawed in the sense that when they adjudicate, they can commit errors. And so they are also not an ideal solution to just leave the courts alone and let them just apply the principle of tort law. So when states have to choose how to regulate a technology, a risk like this one, they have to choose between two equally flawed alternatives of regulating and be subject to capture or incompleteness or being outrun by the technology itself, or leave it to courts, but with an unpredictable and suboptimal decision-making at sometimes. So regulation has, however, grown exponentially, and states regulate uncertainty and scientific complexity very often. And also when the population is more affected, this has been demonstrated in the writings of enforcement theory of regulation. And so this is particularly applicable to AI when we think that there's uncertainty, certainly, there's scientific complexity, and more, the population will be affected as consumers at work, but also because states are deploying AI for basic services. So this is a really one situation in which we're probably seeing regulation. Also, states that have certain institutions will be more inclined to regulate, especially those that are grounded in the French kind of legal culture. So this is why we're expecting regulation to happen. But of course, when we ask ourselves when states try to understand if it's better to regulate or to just leave the courts alone, it's not a black-white choice. And regulation actually takes many forms. We have self-regulation and guidelines. For example, Japan, South Korea, and Singapore are following into these steps and providing courts with some guidance as to how this technology can be regulated, but also state, of course, can apply technical rules and statutes, and more we're seeing participatory rulemaking where the industry is actually part of the rulemaking process in AI. So we can expect that the scope for this agreement when it comes to torts brought about by AI will be reduced by the existing regulations on many levels, on what kind of harms, what kind of grounds, what kind of liability this will entail. And in some states more than others, for example, the UK is refraining from adopting any kind of this guidance, but at the same time, it's quite active at the international level when it comes to standardization. So we will see what kind of regulation will come up, but certainly we will have, tort law will be not the only way in which we will adjudicate this technology as other technologies. So AI will coexist with some form of regulation. And given this complexity, I don't think we can come up with a theory of everything about AI and tort law. We will have to break it down according to how the technology is deployed, according to the sectors, of course, according to the various steps of tort liability. And as unsatisfactory as this is, I think it's the only way in which we can make sense of this, given also the heterogeneity of the technology itself. So AI is deployed in society either to help humans doing something, computation, imaging, or even surgery. In this sense, it augments our capacities, and also is deployed to do stuff on behalf of humans, driving cars and others. But of course, this second type of technology is not there. What we're dealing with most of the time is some kind of augmentation of our capabilities. And even in these two types of deployment, AI has different degrees of autonomy. And as Daria said, most of the time, that autonomy is actually only apparent, because if we go on and look at what's happening actually behind, we can definitely trace back at least the chain of causality of what how the algorithm decided to function. Just conscious of the time. So how can we, given all this and this complexity, how can we adapt tort law to the deployment of AI in society? And of course, as I mentioned, we need to break down all the elements. So the harmful events, what can happen, tortfeasors, who can be blamed, damages, and in particular, if there is some kind of specific damage that can be linked to AI. And on top of that, it's very important to be cautious of the cross-border dimension of AI as a technology. It happens online, and most of the time there's no physical output. Sometimes there is, but sometimes there's not. So that will certainly have an effect about on how single states will come up with a solution in tort law and AI. So because of time, I'm just going to take some examples to see how these adaptations can be done. So about the tort fees, I think Daria already mentioned the highly dispersed control that exists on AI systems. So of course, this is a technology. So the first reaction would be to just, kind of, if there's a damage, try to blame the manufacturer. And we know this complexity. The manufacturer can be the manufacturer of the product itself, or one of the components, or someone who presented himself or themselves as manufacturer. And this is not very complicated. But there are other agents, other persons, either legal or physical, that can have some degree of control on an AI system, in particular the front hand and back hand. This is also to be taken into account when we speak about accountability and liability. The user themselves of an AI system, they can be consumer, professional, or even states, state administration. They can also bear some of the responsibility of harms. And we're seeing this, for example, with the Dutch benefits, child benefits scandal. Of course, the administration had a contributory role in that. And of course, as always in tort law, we can also have interfering third parties like hackers. So in all of this, it will be difficult to find someone to blame, or we will have to adapt our ways of thinking about causality. I also agree with Daria on this. There are a few principles that are elaborated at the international level, and that many states seem to share in two separate documents, but they are quite the same principle in the OECD recommendation and G20. Of course, transparency and explainability. So this idea that meaningful information about the functioning of the system has to be available. So anyone who's adversely affected needs to be able to challenge the outcome of an AI system. So this will be reflected in the regulation. And then, of course, now the courts will go on and apply the law. The same can be said with these other principles that seems to be shared globally: robustness, security, and safety. And again, just reading the bold words on the screen, you can see that the idea is that we have to be able to understand what happened and who's responsible for this. There's also an idea of constant monitoring and risk management on the part of the people who have part of the control on AI. And the last principle, of course, that is relevant at the global level is accountability, and we'll see this again. So another point, and I think on this one, there's maybe a difference with the previous presentation. I think there could also be some kind of damage that is only linked to AI itself. One example could be subliminal manipulation. We do have laws about subliminal manipulation, and there's a prohibition in European law, for example, but it is very restrictive, and it only applies to broadcasting and other traditional services. So I'm just asking, I don't know the answer. One of my colleagues here in Macau is coming out with a book on this, but I don't know if we can actually say that there's one type of damage that is my behavior affected by some kind of subliminal manipulation that happens between or because the deployment of this technology. Another example could be biometric identification, which is prohibited in the EU. I'm finished. What if that technology is deployed? Is there some kind of damage that can be linked to the use of this particular technique? And finally, is this the last slide? So the cross-border dimension that I mentioned before can also lead to a perfectly good tort law system applicable to some AI system in one state. But when the cross-border dimension happens, maybe the interference between the two can create a negative conflict where someone can actually not be held accountable because of a negative conflict of laws. So I think in that particular respect, we can use the experience that we have in product liability and just try to understand which bits of control, a person that has bits of control on the process, which law they are expected to abide with. And that could be a good guiding principle. I'm sorry if I exceeded the allotted time.
Okay. Thank you, Sarah. Sorry, I'm just really heartbroken. I have to stop you guys. Thank you so much.
Yes.
And I just think we're gonna have a lot of questions. So I just want to leave enough room for the Q&A. Thank you, Sarah. Thank you so much.
Thank you.
We have a fourth speaker. We have, ladies and gentlemen, Advocate Joel Slavotsky from the Reichman University in Israel. Joel, I hope it's okay with you if you go a bit earlier. And Joel will present on the state-of-the-art defense in an era of emerging technology and cyber warfare. Now, Joel, please take a second if you need some time to organize your slides, because I kind of pulled. Are you already ready? Awesome. Thank you so much. You're a savior. Thank you so much. Okay, I'm going to mute myself.
So I'm going to thank you, Elisa, very much, and thank you for the CUHK for inviting me and my fellow panelists. It's great to be here. I'm going to be speaking about U.S. products liability litigation, and it's actually, we'll just give you an overview of the presentation. I'm going to give you an introduction. We're going to go through quickly, given the time constraints, obviously expeditiously, the products liability theories, and then I'm going to focus in on state of the art, which is basically the topic of the presentation. And I will divide it up with impact of artificial intelligence on state of the art defense terms generally, and also in terms of cyber warfare. Okay, the whole genre of artificial intelligence and machine learning, I'm not going to go into the specifics of it. I think previous speakers made abundantly clear that it's a very, very broad area. But essentially, I want to take a look at an example. A consumer buys a lawnmower from company X, the model Z4. If it's AI enabled, it's going to continuously learn and become Z5, a different mower, afterwards Z10. The consumer has a model far different than the original Z4. And since each owner's interactions will vary, in other words, if I use a lawnmower on my garden, that's going to be different than the lawnmower that Elisa uses on her lawn, on her garden. And each subsequent version is also going to likely encompass numerous variants. And not every owner's ultimate Z10 is going to be the same lawnmower. So in this respect, fundamentally, the AI-enabled lawnmower, you can use it for any product. I'm just using a lawnmower as an exemplar, is a very different conceptualization of a product than the classic products liability understanding of what is a product. Now, also, there are essentially three very, very important themes that impact on the state-of-the-art defense. One, and this is from former National Security Advisor under Jimmy Carter, Zbigniew Brzezinski. He wrote a fantastic book around 1970 or 71, Between Two Ages, America's Role in the Technotronic Age. he basically said that the curve of technological development is exponentially increasing. He actually predicted the downfall of the Soviet Union. He said that the Soviets were lagging the Americans in technological advancement, and actually his prediction was prescient. So that's something very important to understand, that this is a process, AI, machine learning. This is a process where the progress is increasing, the advancement is increasing. The second is access to technology is also increasing. At no point in history have so many people as a percentage of the population had access to scientific information and the ability to exploit this. Anybody can become a hacker. You can go on to the dark web and you can actually pay somebody or rent out a program and find out how to hack a device. So, that's also another very important development. And the third is that we're at a point in time, and it kind of correlates with number two to an extent, where there's big power rivalry, there's a lot of competition. You could have a state or a non-state actor actually intentionally taking over devices, cars, lawnmowers, or whatever it is, just to create havoc. Now, that being said, let me quickly go through products liability theories. Many of you may already know these from your basic tort classes, law school classes. In the United States, there's basically three theories. It's probably kind of similar in the EU and in Australia, probably Hong Kong also. Design defect, failure to warn, and a manufacturing defect. I won't spend time on this. Manufacturing defect, as you can imagine, means that there's a defect in the process. The product itself is fine, but there was something wrong. Something went wrong in the manufacturing process. The second type of case is a design defect. The product was not designed properly. This also involves a risk utility test regarding the benefits to society versus the risks. And then the big one, particularly in the United States, is the failure to warn that the product is okay. It's kind of like design. I mean, there's a certain amalgamation between the failure to warn and design defect, but essentially what the failure to warn case says is that, okay, there's no manufacturing defect. The product itself is designed the way, it's okay. It's not so bad, but there was a problem and there was a failure to warn. We actually, in a previous life, I actually represented Fortune 500 companies, my firm did, and products liability was a very, very important aspect of the practice, and the number of cases alleging failure to warn is extraordinarily high in the United States. And basically, the manufacturer failed to put a warning on it, forgot to or failed to communicate specific hazards, didn't give instructions. And obviously, there's a reason for that, because the more instructions and the more hazards that are given, the less likely a consumer is going to look to buy the product, and they want to make a sale. Unfortunately, none of my clients, but I've heard that there are defendants that put profits in front of people. So, you have to always keep that in mind. Now, this is from the patent jury instruction, the model instructions in New York. A manufacturer that sells a product in a defective condition is liable for an injury that results from the product when the product is used for its intended or reasonably foreseeable purpose. In other words, you don't have to warn on something where it is unforeseeable that somebody is going to put their hand in the snowblower. Okay, it is not really foreseeable, though a lot of companies are putting in those tremendous warnings as, don't put your foot under the lawnmower. It's common sense not to, but they're still doing it. I'm going to move. Okay, let me get to state of the art, which is the heart of what I want to talk about. A defendant can present evidence to the jury that it should not be responsible because at the time of the manufacture, the defendant did not know and could not have known, based upon the scientific knowledge at the time, also known as the state of the art, that the product could have been designed better or that it should have had a warning on it. And the term state of the art itself is subject, obviously, to a multitude of definitions. And again, as many of you know, or maybe some of you don't know, in the United States, there is no real federal tort law. It's depending upon the state and different states have certain nuances, but essentially it's industry custom, industry practice. And the idea is that the manufacturer should not have put a product out that they knew or should have known was dangerous. And appeals courts will uphold these type of judgments. This is a quote from a 2007 case. As the trial court properly determined, the defendants made a case that based upon the state of the art, the devices as comparable machines produced by its competitor, it conformed with that. So there shouldn't be a liability. The manufacturer is considered an expert. They are considered to have to keep up with the state of the art. They have to keep up with the scientific knowledge, and it has to be based upon peer review science. It cannot be junk science. There was a case where the tobacco manufacturer wanted to invoke the state of the art defense based upon a document called the Brooks Memo, which basically was a survey of quote unquote distinguished scientists that said smoking is okay. It's not a big deal. And the court precluded that because it wasn't peer reviewed science. So what is the impact of AI on state of the art? Well, AI is in many ways similar, as was mentioned earlier, to previous technological advances. It obviously is. So to that extent, there is no major change. However, artificial intelligence is also inherently different because the product may not be the same as it was originally manufactured. And for example, should artificial intelligence have learned to recognize malignant cells in a diagnostic test setting, or is the controlling factor whether that capability existed at the time? Now, here are some general questions that I would ask. Is the manufacturer an expert based upon its industry peers? And should that be basically encompassing all AI for that industry, or what about for other industries? For example, what if in the lawnmower industry, taken 5 years from now, okay, lawnmower, or 10 years from now, lawnmowers are going to have this capacity and this capability of learning based upon the user experience. Well, should the manufacturer be held to the accountability of knowing what all of the other AI programmable lawnmowers are in that industry, or should it also encompass the expertise of AI, so to speak, or the competency of AI that go to other products, not just lawnmowers? Is it industry specific, or should it encompass many other aspects of manufacturing? And obviously, what should constitute reasonable efforts at maintaining expertise? What about collaborations with governments? Is artificial intelligence, should it be used as part of the state-of-the-art defense only when it is generally accepted? What if it's not generally accepted at the time? And it should have been generally accepted at the time. And what determines what exactly is generally accepted? Can you really have a standard in an industry? Again, this is very different from having specifications, voltage, a voltage regulator, the size of the blades, the distance. I understand that, but we're talking about algorithms, we're talking about the capacity to learn, and can there really be an industry-wide standard? I'm not saying there cannot be, but I'm not sure how you put that together. And again, in contrast to traditional products that do not learn, was the product reasonably safe when it was sold, or was it the prior owner's personal experience so different than what was reasonable? And then you also have questions arising from cyber warfare. In classic products cases, there is a presumption of negligence. It could be gross negligence, recklessness. Generally, it's not intentional. Here, there's a possibility of groups endeavoring to take over the product while being used to purposely cause damage or obtain data. And therefore, what is the impact on the state-of-the-art defense arising from the prospect of an intentional takeover of products? Do manufacturers need to incorporate cyber warfare into their products? And if so, how extensively? What about dual-use commercial military fusion? do manufacturers have the duty to build cars able to withstand being commandeered by a foreign nation or terrorist organization? What about hackers? Hackers are, prevalent. Send over your Bitcoin to this address, or we're going to release some terrible malware or whatever it is. Well, what is the responsibility of the manufacturer, and how do you establish a state-of-the-art defense when these technological advances continue to move? Again, it's very easy with electricity. A certain amount of electricity, if you can get electrocuted, you will die if for some reason the voltage regulator fails on that product and you get a surge of electricity in your body, you will die. That does not change. But this type of technology does change. And what is the responsibility? How do the manufacturers establish that? I mean, do they have to have a product connected with a data source 24/7 to learn from additional data? I don't know. Well, in conclusion, and it's good because I only have another minute or so, a minute and a half, AI engineered products, and in particular products that inherently learn, are dependent upon consumer interactions, or they will be dependent upon consumer interactions to be functional and safe. And there are gaps in the existing legal framework that are inevitable, and we need to better understand how the state-of-the-art defense is impacted by AI. And in conclusion, a consumer buys a lawnmower, as I started out, that lawnmower ultimately is substantially different than an original lawnmower. And my lawnmower is different than Elisa's lawnmower, which is different than Sarah's lawnmower, which is different than Dara's lawnmower. And it is really unclear to what extent traditional products liability framework can be presumptively governing the state-of-the-art defense in the context of AI. Anyway, thanks. And I think I kept with my time, so I turn it back to Elisa.
Okay, so I'm gonna start to warm the audience up a bit. I'm gonna start with Joel, but because I mean you were indicating that we have similar lawnmowers, so but please, Daria and Sarah, I mean those are also kind of direct to you. Okay, so there was a lot of talk about developing AI, machine learning, and we used the words autonomy and automation, etc. And there's always in the background a little bit of this insinuation that this little thing called AI becomes independent. We're not really saying this, but it's floating in the background. Okay, so this lawnmower just walks off and starts, I don't know, killing people or cutting all the flowers. Now, some technical guys, it wasn't actually lawyers, basically, so the technical literature points to the simple fact that we can develop a super sophisticated machine learning algorithm, but then on top of that, you can simply install safeguards. So even if it learns, it, for example, can't exceed a certain speed. Or if it's a trading algorithm, it can't submit offers outside of a certain trading range. So I was just thinking about this low machine learning based semi-autonomous lawnmower, because I mean the problems you have presented are actually quite severe. But one thing is the algo, whether it's machine learning or autonomous, whatever, or advanced or level 6 above automation. But ultimately, the manufacturer can just install safeguards so the thing doesn't go off the rails completely. What do you think?
Well, it's a great question. I think you're right. I think clearly you're always right. No, really, I do think Elisa, listen, you know much more about technology than I do. I think you're right, and I think certainly there can be safeguards put in. I would only respond and say we know of the, for example, Tesla car that has that built, well, I think it was Tesla, that saw the truck and thought it was a clear sky. So I'm looking at it, not that the lawnmower is going to have a mind of its own and start to, it could be taken over, it could be hacked, and yeah, I mean that would be a very dangerous scenario. But what if the lawnmower kind of like sees electrical wires that it should not be cutting, and then it sees them as flowers by some sort of mistake in the programming? And the question is, did that lawnmower not learn properly during all of its experiences, and would the manufacturer then be deprived of using the state-of-the-art defense? Because the manufacturer could say, listen, when we manufactured the lawnmower, this was the state-of-the-art type of algorithms, and it should have learned it, and so therefore it's a mistake, but it's unforeseeable. Or within the context of the state-of-the-art defense, should they have looked at other types of industries and said, wait a second, our algorithms are not so great. Maybe we should also encompass these other types of algorithms so that the lawnmower can learn and not think that the electrical wires were in fact flowers and electrocuted.
I'm afraid you're right, because I think your example actually shows that no safeguard can be implemented if the machine learns something incorrectly. Because the safeguard that I normally talked about is, trading above a certain or below a certain range, or, acceleration if it's a car. But distinguishing, cables from roots or flowers, you can't really safeguard against this unless you train specifically for it to differentiate cables from. I think cables and flowers is not such a big problem, but roots for a tree, then of course it could destroy, we could have like a, I don't know, blackout in the entire neighborhood. Yes. So I think you exemplified that safeguards may not work in certain areas. Okay, I concede defeat.
Well, you stated it much better than I did. Your exemplar was excellent. I agree.
Okay. Thank you for this. We have a very shy audience today, or maybe they're just keeping the screens on and everybody's already at the chairman or in some bar. But okay, to Daria and to Sarah, because I know that I'm not really following the developments in the EU that much. I remember the 2016 proposal about granting legal personhood for the purposes of liability specifically. Tortious liability was mentioned in the first place. Daria or Sarah, I'm not sure who is the better person to ask. What exactly happened to this proposal? Because there was a lot of headlines and a lot of people were very enthusiastic about it. So Daria or Sarah?
I don't know. So I simply say, I don't know what happened to this proposal. So maybe Daria can be of more help.
Well, the proposal simply stalled. I mean, there was no further development. This idea was abandoned. It was indeed criticized as completely ridiculous and not helpful in any way. And I do believe that the strong response of the scientific community did play a role, pointing out that this is simply does not correspond to the real life problem. And even now, I want to point out the current two initiatives, the AI Act and this adaptation of the liability framework for the digital age. They both are still underway, and you can find the public consultations and the responses from the industry. Basically, very often you find the criticism of not understanding the real life problems. And I also worked on AI and intellectual property rights, and here we have a completely different discussion, but it boils down to the same question of the relevance of the human input. And then we have also exciting discussions of the AI creators, inventors, and so on. And then you read the feedback from the research community, who again says that this is simply ridiculous at this point. So this overstated and anthropomorphized representation that might be helpful for simplifying the technological process, but they cannot be just taken as literally. I'm not absolutely against the advancement of the technology, but since you touched upon this idea of the development of a supercomputer, you can find a lot of references and discussions in the technical community who says that basically it's not unclear what exactly we mean by this general purpose, artificial general intelligence, and it's not just simply the matter of feeding more data. It might be a completely different approach to how we model and understand in the first place the cognitive model. So it's at this point it's still very narrowly focused applications. So you cannot imagine a model trained for some task unless there are, of course, approaches for pre-training and retraining models, but it's still very narrowly focused. I also wanted to comment on the first question with regard to the safeguards. I think yes, I still think that there might be. It's not completely irrelevant because at the end of the day, it all boils down to the mathematical optimization of the data points within the model. So the model does not recognize whether it's a root or it does not operate in terms of the whether it is a root or a flower or a cable. It all boils down to the weights, to the parameters, and the process of optimizing the cost function. So I'm not sure. I won't. Maybe I don't have a clear definitive answer how it's technically possible, but I think when we talk about accuracy, there might be safeguards at least to prevent the automatic execution of the choice without the human decision making. In the case of certain maybe amount of the new input data, and maybe to the human eye, the root and the cable might seem the same, but I think when you break it down into the millions of data points, I'm sure that the highly sensitive model will be able to distinguish the differences. And it might be, I think, possible to somehow model and inbuild this unusual events, maybe even in terms of the the amount of data that has been that has been added after the implementation of the initial model, so that it at least can stop the automatic execution of the this choice, because what we mean by choice or decision, it's the execution of the probability. Is it 30% of the reward would be maximized, or the cost function will be minimized? It all comes down to the mathematical optimization at the end of the day. So I think that it's the challenges are real. I'm not saying that they are overstated, but I think that it's there is still some room for discussion.
Mm-hmm. I think you provide, Sarah?
Comment on the same issue. It's very interesting what Daria said about the technical part, but I think from the point of view of the law, and in particular the regulation rather than just tort law, I think we need to have some kind of rules at the design level that make it possible to insert some safeguards, because of course the idea that the lawnmower would just take a cable for a root, that is a sensory bug. That's a problem with it, right? And if the problem is instead in what Daria was saying, inserting some kind of common sense, or even, I mean, you can call it ethics, right? You can insert some kind of limit to it, whether you want to, for example, that's very interesting. One interesting example that is brought up by technical people all the time is the tragic plane accident whereby the pilot crashed into a mountain. Yeah. So if you had taught the computer that the basic ethics that you never crash a plane into a mountain, and you just kind of do an emergency landing instead, that's really plain common sense. And so I think that there should be rules on how this is actually made, and that is related also to the state of the art, of course, and to the idea of regulation. If you get the industry to come up with these rules, with these guidelines of how these things have to be made in the first place, and then deployed, and then constant monitoring, I think it's a system that has to work together, not just at one level, but at multiple levels.
I'm afraid we are going to finish this on a slightly sinister note then, because Sarah, I didn't want to mention planes, but the plane scenario you just talked about actually refers to something that Daria was talking about. So, yeah, the plane, there should have been some safeguard that the human cannot crash the plane. And how many people died. And the other problem is, going back to what Daria said, technically, an autopilot, I mean, we don't call it AI, but technically it kind of is a hybrid AI. And guess what happens? The safeguard is, if it doesn't know what to do, it does a handover. The autopilot stops, hand it over to humans. And what happened the last time? It crashed. So on this lovely note, crashing planes, I'm sorry, I wasn't going to finish like this. Crashing planes and regulatory incompetence. Thank you, Daria, for mentioning this, because again, I did not want to say this, because quite often regulators, for some reason, particularly in the EU, they just get kind of seduced by all those headlines, and then they want to grant personhood to AIs and whatnot.